Yes, this one. If you can just allow me.
I want us to go to the tape.
We'll go to the tape, but let me
then begin to talk about the questions on the tape.
There are two things that I need to say. Number one, Frank Davis and Mr. Pencil are contradicting themselves, and they need to see that contradiction.
How?
Because a few minutes before now, they said that the Attorney General had the right and was actually right in objecting to evidence being given by a witness. Few minutes after, they are saying that he had no right to object to evidence being given by a witness, and that the right thing for him to have done...
It's Pencil who said something close to that.
No, he said...
Frank Davis didn't. He didn't.
He said it.
He
didn't. Can go and play the tape.
He spoke about it as a matter of choice.
No. I said it was a matter of choice. They are saying... No, hold on. You see, let's discuss this as professionals. You are saying that the AG, as the prosecutor-in-chief in this matter, had the right to object to Eduji's question and Jakpe's answer about authorization.
That's correct.
Then when it comes to allegations or evidence about his professional misconduct, okay, you are saying that he didn't have the right to object.
No, that he can adopt a strategy.
No, nobody says.
And the strategy is that he will have its day.
So let's settle it here and now. That it is wrong for anybody to say that the AG didn't have the right or the option to do so.
Thank you. Now let's go here. Let's go here.
Not just that.
No, if we are not careful, we'll go into this banter and not go into the meat.
It's 2 against 1 on this particular one. So
no, it's not 2 against 1. These are Pencil is a lawyer making his submissions. Of course, he's with the MPP. So we can say that.
Let me also say that the fact that a lawyer in a matter may have the right to 2 options, okay, either to object to evidence at the time it is being offered per Section 6 of the Evidence Act, okay, read together with Section 52, or either to wait for his turn to cross-examine and undermine that evidence. The two are not mutually exclusive, and the lawyer can do both. And this is the first time such serious evidence will be given against an Attorney General of the land.
Okay.
So when they talk about the practice,
thank you.
There is no practice of this.
I can tell you that from the benefit of practice, there are questions I can keep quiet about because I don't want to alert you before I start cross-examining you.
Yeah. So you
I don't want to alert you. I want you to get, when it gets to my time, then I put you under.
So why didn't you do that on the issue of authorization?
Right, so let's move here. I didn't want you to come in. That's why I wanted to close it.
That on the issue of
okay, do this quick and let's go. Quick.
With good respect, I don't contradict myself.
All right.
So don't put contradiction in my mouth.
Right.
If you listen to me carefully, you appreciate what I said. I never contradicted myself. And that has been pointed.
Viewers,
thank you. So now let's go here. Let's go here.
Listen to me.
Let's go here now. We have taken care of 2 major issues. And we are going to unpack it in this manner for you to appreciate. Follow us because this is law. We can't do it any other way. Now, the Attorney General made no mistake in the intervention, number 1. He made no wrong. He did not breach any law. Number 2, that he did not reply. In fact, he did not have the right of reply. He can cross-examine the party on it. He can also object to what he said. But it is also a legal strategy for a lawyer to decide that instead of objecting, I will wait when it gets to my turn and I use the same information against you. So we have settled that. The fact that he did not reply doesn't mean he's guilty. Now let's come here. In the tape, the AG is seeking cooperation of the accused contrary to the AG's public statement, paragraph 2. Kweku Pencil, do you agree or you do not agree?
When parties meet to do what we call a settlement or plea bargain, everything is allowed between the parties, subject to the overriding concern that it is that discussion, once it is in camera, it is not for the public consumption. It is a trading. The parties, and therefore, it is in absolute bad faith. Because, see, what is happening is that we've got a party who attended the meeting with a mind to report the meeting. Be very careful about every statement that he makes, whilst at the same time giving an impression to the other party that We are trying to settle this case, and we are doing a trading, and of course, allow the Attorney General to say everything that he needed to say. I find absolutely nothing wrong with anything that the Attorney General said within the context of a settlement.
Okay.
Because it was a trading.
Mr. Pinso,
yes.
Mr. Pinso, this is the question I'm asking you. It's a direct question, and I'm picking it from the AG's statement. In
Yes.
paragraph 2 of the AG statement issued on the 23rd of May, 2024, it reads...
Yes, I'm listening.
It reads, the Republic has never required or desired the cooperation of any of the accused persons in this matter, in which it has already succeeded in establishing a prima facie case against all the accused persons. Operating phrase, has never required or desired the cooperation. I'm asking you, from the tape you have heard, the AG in that conversation is seeking the cooperation of Japa, contrary to what they say in the statement, not so?
I agree with you, but I will repeat that insofar as that discussion was held in a without prejudice context, it is in absolute bad faith that one party attends a meeting with the knowledge to report a without prejudice discussion and then turn it into the public domain. So therefore, the judgment that the public must properly be making is not that statement on its own, but within the context. Because forget about what I told you.
Did we lose Koku Penso?
Of the day, it's not even much what Attorney has said, but I am compelled to say what I'm saying by reason of the fact that the statement which is being put to the public for assessment or being put to me for my
We are losing you. We are listening to you once in a while as you speak. Hello, Koku Penso. Okay, so hello.
Within context, yes.
We are having a challenge with your line, but I needed you, if you can do this in a minute for me. You confirm that from the tape you have listened, the AG was seeking the cooperation of the accused. That's what your confirmation is.
That is so.
And the AG issues a statement and says they have never required or desired the cooperation of the accused. What do you say about that?
I'll put it in the same context that within the court trial, the trial which is in court, they've never, but in an out of court settlement or in a purported attempt to settle the matter of court, there's nothing wrong if you sought the cooperation of any of the parties to compromise the case. A normal practice in our legal profession, which is guided by law.
Okay, so we'll get there as that issue also, because that's the thrust of all of this. Whether the AG was doing something wrong and the accused person had a lawyer or had no lawyer. Sami?
Well, it's very sad that Mr. Koku Penso will seek to mislead the public in this manner. Now, number one, Samson, you refer to a tape recording, which is a recording of a telephone conversation, not a meeting. So this issue about plea, bargain, negotiations, or meeting is neither here nor there. That call was a call placed to Mr. Japa on the morning of 9th April 2024, a day he was supposed to appear in court to testify. It could not have been a plea bargain negotiation. Because number one, the Plea Bargain Act, Act 1079, is clear. Plea bargaining can only be done with a represented party through his lawyers. On the 9th of April 2024, Mr. Japa was represented by the respected lawyer Thaddeus Sori. He could not have been having that conversation with a represented party and call it plea bargaining. Again, the Plea Bargaining Act is very clear.
The spokesperson for the Attorney General has said that Mr. Gyamfi was not represented at the time of the conversation.
Which is a lie. Because the conversation, we have shown you the WhatsApp record, was on the 9th of April 2024. And on 9th of April 2024, go and check the court records. Tadio Sore was lawyer for Mr. Gyamfi. So another lie. Okay, so this has got nothing to do with plea bargaining. In fact, if you read the Plea Bargaining Act, before you even begin plea bargain negotiations, the court has to be formally notified. And that requirement is mandatory. It says, shall notify the court. And an adjournment given for that purpose. Now,
I can agree with the other party before the court gets to become aware, and then we just tender the settlement terms before the court. The court will adopt it. The court will not say because we didn't notify it, it will not accept it.
But then can you agree with that party without this lawyer? Will you do that, Samson, per your training?
The law prohibits it.
Exactly. Rule 56(2)(d) of LI 2423 is clear. A prosecutor cannot confer with or interview an accused person. Open and shut. A prosecutor cannot confer with or interview an accused person. Rule 13 of the same LI 2423. And for those who don't know, this is the Legal Profession, Professional and Etiquette Rules 2020, LI 2423. Rule 13 is clear that a lawyer cannot communicate with a represented party directly.
Rule 13 says,
yes,
a lawyer shall not approach, communicate, first approach, communicate, or deal with a represented person on a matter, or attempt to negotiate or compromise a matter directly with a represented person, except through or with the consent of the lawyer of that represented person.
So when Mr. Kwaku says that per the practice this is normal, that conversation, what is he talking about? Has he addressed his mind to this rule? This is Rule 13. Let me read to you Rule 56.
His major concern, as I understand him, is that this is a without prejudice conversation. And a without prejudice conversation ought not be put in public because it cannot even be admitted in the court.
It is only a plea bargain conversation which is without prejudice. I have demonstrated to you that this was not a plea bargain conversation. All the requests for plea bargain from the letter of 27th April to Gyamfi's letter of 16th May to his 30th May letter and the 12th of June letters, according to the AG, were all rejected by him. So, according to the AG himself, he has not had any plea bargain negotiations with Mr. Gyamfi. We are talking about a telephone conversation on 9th April 2024. Yeah, that's what we are talking about here. A day the witness was supposed to go to court to testify. How can you be having plea negotiations on a morning of testimony day? No, the same morning, the same day. And Rule 56, 2D is clear. A prosecutor shall not confer with or interview an accused person. You understand? So by calling the accused person and coaching him, persuading him to give testimony not based on matters within his personal knowledge, but within the knowledge of the AG, and to skew his answers in such a way that supports the AG's case, because the AG kept on saying in the tape that those answers will create no difficulty for him if he did so. And even when the witness was saying, I can't do this because I will be dishonest and I will be implicating an innocent man, the AG was still hell-bent on pushing him to do that. He breached Rule 13, he breached Rule 56 2D, he breached Rule 54 because he was telling a witness to give testimony that in the knowledge of the witness was false. And what is even worse is that he breached Section 213 and 214 of the Criminal and Other Offences Act, Act 29, by telling a witness to forge a fake medical excuse duty to deceive a court, which is the crime of perjury, second-degree felony. Now, to conclude, just one sentence to conclude. This is very clear, and Mr. Kwaku Pensel respectfully has admitted that what the AG said in his press release of 23rd May 2024 to the public, that he has never sought the cooperation of any of the accused persons was a barefaced lie. And that demonstrates the lack of integrity, the lack of character of Bisa Godfrey Adame. The more reason why he must be sacked now.